A recent argument a contractor made to the Contract Board of Appeals in the Defense Department might lead companies to the wrong conclusion. It's another case of a company trying to recover unanticipated costs under a fixed-price contract, costs incurred because of the COVID pandemic. The case is about jurisdiction, though, and not cost recovery. We get details now from Haynes Boone procurement attorney Zach Prince. And Zach, you're saying this particular case is causing people to think, oh, goody, we can get recovery for costs that we didn't know we were going to incur, but you're saying, not so fast.
Yeah, that's right. It's getting a lot of press, and I think there's a good reason for it. People incurred a lot of costs over the years when COVID was really a hot issue and folks were stuck at home and people couldn't work, and they've wanted to recover it for years. And there have been mechanisms, and Congress passed the CARES Act in Section 3610, which glad to talk about a little bit more, but not that many companies really got relief there. This case could involve that ultimately, where a company does get relief under Section 3610, but it might not. We don't know yet.
Well, tell us about the particular case.
So this case was brought by a company called Aviation Training Consulting. They operate, maintain, support, and upgrade the trainers for the B-52 bombers for the Air Force. So in 2010, they had people who were home because of COVID, and they thought they ought to get relief under Section 3610. 3610 was a congressional grant for agencies to have authority to modify terms and conditions of contracts without consideration to reimburse at contract billing rates for any paid leave that a contractor provided to keep its employees in a ready state. So the authority was limited. It only applied to a contractor whose employees or subcontractors couldn't work on site because of facility closures or other restrictions. And in this case, Aviation Training was seeking $512,000 or so from the government under 3610. But 3610 ultimately was a grant of authority. It wasn't a mandate that the government had to give that money, which I think is the basis for this case. The contracting officer denied the claim, Aviation Training appealed, but then the government moved to dismiss for lack of jurisdiction.
And whose jurisdiction did not have the authority?
This was at the Armed Services Board of Contract Appeals, and the government said, hey, this was never a basis for a valid claim and is not the basis for a Contract Appeals Act appeal at the board. And so, board, you've got to kick this.
Right, but the board disagreed with the government.
They did, and I think it was a pretty straightforward application of the law. Again, I don't know where the government's really coming from. I think this is the second time in a month that we've talked about a case where I just have no idea where the government's coming from. Here they said, well, it's really not a claim because there's this sort of unfettered grant of authority to the government to consider or not to consider these requests. Well, that's not what a claim is, right? A claim is defined really broadly under the Contract Disputes Act as something relating to a contract with the government. Relating to a contract is broad. This clearly relates to a contract. So on that basis, it is a claim, and the board does have jurisdiction.
So the board disagreed with the government and said, we will take this case, in fact.
Yeah, that's right. The government tried to analogize this to Public Law 85804, which has also gotten a lot of focus in the past couple years because it's a basis for the government to grant extraordinary contractual relief to contractors. So if you've got crazy costs that you didn't anticipate and it's going to knock you out of business and your business, the government has to continue, they might consider granting you relief under that statute. That statute is clear that there is no appeal authority under the CDA. So the government said, hey, this is the same thing, 85804, CARES Act, but here's a problem. 85804 clearly doesn't permit jurisdiction, right? No such thing exists in the CARES Act legislative history or language of the statute.
We're speaking with procurement attorney Zach Prince. He's a partner at Haynes Boone. So therefore, from the face of it, it looks like then aviation training consultants do have a claim that can validly be brought to the Contract Board of Appeals, which will then have to decide on its merits.
Yeah, that's right. I mean, I suspect what they're going to do is try to argue that the government abused its discretion by not granting relief under 3610, which is a pretty high bar. But, they'll get their chance to explore that theory, and the government can't kick it prematurely like they were trying to.
I think, I have some suspicion the government probably in its mind, in the minds of the contracting officers, probably don't disagree that the contractor might be entitled to this compensation. In this case, it's only $500,000 only. Big deal to the contractor, not that big a deal to the government. But with the threat of a continuing resolution for the rest of the year, for the lack of new budget authority, new appropriations for the current fiscal year, I just wonder, as a practical matter, they wonder if they'll actually have that money at the end of the year.
I have to guess that this is money that would have been from prior year appropriations. But you're right, Tom. I'm seeing a lot of that where the agencies are being penny pinching might be the nice way to say it, with the ways that they're granting relief or issuing new contracts for things that they know they need, where they're doing it in half batches basically for what they really will need for the whole year, because they just don't know how much money they're going to continue having.
Right, and the CARES Act did not necessarily appropriate money to give to agencies to cover contractor costs incurred because of the COVID.
No, it didn't. And that's been the problem with some of the other reliefs that Congress have granted, and like the National Defense Authorization Acts for the past 2 years. Both of those, 2024 and 23, had provisions authorizing the government to grant relief for cost increases due to inflation. But both of them were contingent on appropriations. 23, it never happened. I sort of think 24 is not going to happen either.
Yeah, right. And so the government has fixed costs, and there's a automatic reduction of 1% should the CR go for the entire year. That's an old budgetary rule. So there's really no money in the accounts to pay for ongoing costs of a contract. And I guess maybe the government looks at it, I'm just trying to guess what the Air Force might have been thinking, is, well, they're still in business. They're still providing us B-52 training systems. I'm just going to look the other way and let them eat it.
That might be the case. I mean, we're starting to see programs getting cut. I don't know that FARA getting cut had to do with budgets, but maybe. And I think we're going to start seeing other big programs that are being squeezed in ways that nobody's happy with because of these budget issues.
Yes, because contracting costs are really the only, in some sense, variable costs the government has. You can cut training and travel for people, but that's trivial compared to contracting spending. And if you need to squeeze, that's your accordion bellows.
That's right, but it doesn't really support a robust defense industrial base, right? And we keep hearing time and time again that the industrial base is shrinking and there are too few companies willing to do business with DoD and the government at large. Well, this is not how you help.
Procurement attorney Zach Prince is a partner at Haynes Boone. Thanks so much.
Thanks for having me, Tom.
And by the way, the CDA will decide this case, so you'll be watching to see what they actually say on the merits.
We'll all be watching. I mean, with the low dollar value at issue, I suspect there's going to be a settlement if there's any merit, but you never know. Maybe there'll be a decision on the merits ultimately.
And the merits of the case may not necessarily be the claim that the company has, but simply whether the government was correct in exercising its discretion. That's a big distinction.
Yeah, it is. And the government has quite a lot of leeway in exercising that discretion, right? It has to be rational, and rational is a pretty low bar. So if the contractor is going to prevail here, they're going to have to demonstrate that it was totally beyond the pale for what the government did. They had money. They could have given it out. They should have given it out. Any reasonable person would have. That's a really high standard to meet.
Yes, so the contractor still has the high bar here and the government the low bar, to put it simply.
Yeah, that's right. I mean, I don't see the contractor likely to prevail, but I don't know any of the facts, really. So we'll see what happens.
Well, somebody's got to fly those 8-engine planes. We'll post this interview at federalnewsnetwork.com/Federal Drive. Hear the Federal Drive on demand. Subscribe wherever you get your podcasts. And this program note, every day this week, our special report is highlighting the 85% of federal employees who work outside the Washington, D.C. region, led by 28 federal executive boards nationwide. Learn more at federalnewsnetwork.com.